Court TV is gearing up for 2 sentencing hearings in cases that we've been covering. But first, Karen Reed will return to court tomorrow for a hearing ahead of her killer or cover-up murder retrial. Now, earlier this month, the Massachusetts Supreme Court heard arguments from her attorneys asking for the top charges to be dismissed in the death of her Boston police officer boyfriend, John O'Keefe, on the basis of double jeopardy. Now, Reed is accused of backing her SUV into O'Keefe and then leaving him to die on a snowy road in 2022. Now, she claims she was framed in a widespread cover-up by local law enforcement. Tomorrow's hearing will address the Commonwealth's motion to obtain cell phone records from various people, including those belonging to Reed's father. Now, a judge granted a defense motion to unseal sidebar conferences from the first trial, but only for the lawyer's use, so the Commonwealth's new prosecutor could get up to speed. Judge Beverly Canone granted the prosecutor's request to have an independent expert reassemble and retest the black box and infotainment system in Karen Reed's Lexus. The Commonwealth said the retesting was needed because data was missing from the first round of analysis a defense expert conducted for the first trial. Now, Judge Canone is also considering a joint motion to push Reed's second trial date from January to April. The judge also scheduled evidentiary hearings, including hearing possible testimony for a dog bite expert for December 12th. Now to Nevada, where sentencing for the Judge Jumper attempted murder defendant, Deborah is happening tomorrow. Now, Redden was facing charges stemming from an incident where he leapt over the bench and attacked Judge Mary Kay Holthus as she was sentencing him for attempted battery charges earlier this year. But the Las Vegas trial ended abruptly when Redden changed his plea during the second day of trial back in September. Court TV anchor Ted Rowlands has a look back at this case.
On January 3rd of this year, Deborah leapt and tackled Judge Mary Kay Holthus. He was in court for sentencing for a probation violation connected to an attempted battery charge, which stemmed from allegations that he had attacked somebody with a baseball bat the year before. Moments before the courtroom attack, Redden asked to stay on probation instead of being sent to prison.
Based on my criminal history, I feel that I should be sent to prison for a second time.
Have you looked at your criminal history?
Holthus did not like his criminal history.
3 felonies, gross 9 misdemeanors, multiple DVs.
I'm in a better place in my mind, my mental health. I have a support system. I just got hired as a teacher for, a union.
After stating his case for leniency, Holthus began to sentence him to prison.
I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada, this court...
According to court documents, Redden punched Judge Holthus in the head and pulled her hair, and punched a corrections officer multiple times and spitting in another man's face. The court marshal, who ran to help Judge Holthus, tripped as he tried to detain Redden, dislocating his shoulder and cutting his forehead, requiring 25 stitches. This left Redden facing a slew of new charges, and as jury selection began in this new case, he ended up pleading guilty to all of them, except one, attempted murder.
And in Florida, a mother is facing 25 years to life in prison at her sentencing hearing tomorrow for the buried-in-the-backyard murder of her husband. Laurie Shaver was convicted of second-degree murder in the fatal shooting of Michael Shaver. A jury deliberated for just under 4 hours in September to determine the fate of Laurie Shaver. She was convicted of killing her husband and burying him below a concrete slab in the backyard of their home. During her testimony, she told the court that in the moments leading up to the alleged shooting, she was being physically abused by Michael Shaver before she heard her ex-boyfriend, Jeremy Townsend, fire a shot. But before Shaver took the stand, Townsend testified and told the court that he didn't shoot anyone. And to throw another wrench into the machine, Shaver's 14-year-old daughter, who was 7 years old at the time, took the stand and told the court that she pulled the trigger on the victim. Now, at the end of the 5-day trial, the jury found Laurie Shaver guilty of second-degree murder in the November 2015 shooting of Michael Shaver. Tomorrow, a judge will decide if she will spend the rest of her life in prison. Let's bring back in our guest. Joining us to discuss, criminal defense attorney, former prosecutor Marsha Minot, and former prosecutor and civil defense attorney Randolph Rice. Thank you again, guys, for being with me this evening. Marsha, I'll start with you, and I'll start with the Karen Reed case, because I'm really interested to find out what is on the black box and the infotainment system. According to the testimony we heard at the hearing, only about a third of the information was available in the previous trial. I think if they get to 100% of that information, which according to the expert he thinks they can do at this point, this case might not even go to retrial. I think what might be on that black box might have all the answers everyone needs. It might lead to a plea deal in some sense.
If it does, it would, because no defense counsel is going to take their client to trial in a case where there is substantial evidence to prove their client's guilt beyond a reasonable doubt. So if that black box comes back with some damning evidence to show that she actually did cause injury to the deceased in this case, I don't see her going to trial. I see it being resolved.
Yeah, it's interesting, though, Randolph. I still contend, after all that's gone on regarding this trial, the cover-up, all this other business, or the claims of a cover-up, I'm not going to say there was one. Certainly there was a lot of evidence. There were a couple of definite officers who had some issues and have now found themselves either without a job or on suspension, that the state in this case might be very reticent to take some kind of plea deal. I think they have an ulterior motive. They want to find Karen Reed guilty, but they also might want to clear the name of their police department.
Yeah, there's a lot of different factors in this case. They're sort of pulling in different ways and different angles. You've got obviously Karen Reed's position as to what she says happened or didn't happen that evening. But you've also got the state who's trying to protect maybe or clean up their image. So it's not really clear cut. I think tomorrow we're going to learn a little bit more. You're right, that black box is going to probably, it may help, it may hurt both the state and the defense, but we're going to learn a little bit more. This is obviously important because the state and the defense are cleaning up or maybe preparing for that trial to see what's really going to be introduced as evidence so that they have a better picture as to does she take a plea, does she not. So I'll be interested to see what happens tomorrow.
Yeah, me as well. I'm also interested in this Deborah Redden case and his sentencing coming up tomorrow. Again, he pled to attempted murder. At the end of the day, I wasn't so sure that that was an attempted murder. And Marsha, I want to get you to speak to that. We've seen the video. It was awful. There's no doubt it was a serious aggravated assault, all these other things. But I'm not sure it rose to the attempted murder level. What do you make of it?
I don't think it rose to that level either. I think this is an overkill and overcharged, but it's not uncommon when you have a case that becomes high profile, when you have the alleged victim being a judge in a high esteemed position. We have to be careful, though, that we're not treating victims differently depending on their position. So I would not have proceeded as a prosecutor in this case with an attempted murder. I don't think he had that intent. Based on his mental history, I would have tried the manslaughter or the aggravated assault.
Yeah, I might have taken this one to trial, too. Randolph Rice, your thoughts on that as well? Again, we know that there were mental health issues. Now, we've seen him in court after, even as his trial began. When he's medicated, he's normal. He doesn't commit these types of acts. It sort of comes down to this idea that he's unmedicated, and you can see the type of background he has in terms of a criminal history. What do you make of this?
Well, Michael, I think you and Marsha are both right. I think it was probably overcharged. I think it was probably an aggravated assault. But I also take note of when you listen to the judge, when she was talking about the sentence that she was going to give, and he was saying, I'm in a better place, I'm working for the union now, I'm emotionally better. And she says, you know, I just don't think that's right. I think we're going to do something different. She got it right. She was clearly correct because his behavior was not different. He clearly acted out in court. You know, it's a shame, this whole situation. It's one of these ones, you're right, it made national headlines. It's all over social media because of the just crazy nature of his behavior in court. So, you know, I'll be interested to see how this keeps moving forward.
Quickly, I only have a couple of seconds left here, Marsha. You mentioned that, you know, in terms of the position of the defendant, you don't want to make sort of decisions on that. But I think the victim matters. And I think that this happened in a courtroom and it happened to a judge. I think that matters, and it should matter in the charging decision. You don't agree?
I don't agree. I think it should matter when it comes to training of your sheriffs. Your sheriffs are responsible for protection of the court. And if your sheriffs don't realize that a court is about to sentence someone and there's always the propensity that that person can become violent, then the sheriff should be held accountable.
Wow, okay, fair enough. All right.